On March 10, 2015, new Superintendent's Rules 66.01 through 66.09 and amended Superintendent's Rule 73 were adopted by the Supreme Court of Ohio. The rules make some major changes in the practice of guardianship law in Ohio. My name is Charlotte Coleman Eufinger. I am the probate and juvenile judge in Union County, and I have been asked to provide a short overview of the new rules, which will become effective on June 1st of this year. The new rules resulted from recommendations of the Supreme Court's Advisory Committee on Children and Families and are based on the standards of practice for guardianships developed by the National Guardianship Association as amended to comply with Ohio's laws and practices. The purpose of the rules is to standardize guardianship practices throughout Ohio and elevate the role of guardians by establishing minimum guardianship standards or benchmarks. The Advisory Committee's guiding principles were to respect judicial integrity and discretion and to safeguard the personal and financial welfare and safety of adult wards. Superintendent's Rule 66.01 to .09 can be divided into three general topics. Superintendent's Rules 66.01 and .02 apply to the overall scope of the rules. Superintendent's Rules 66.03, .04, and .05 discuss the requirements and responsibilities of the courts in adult guardianships. And Superintendent's Rules 66.06, 07, 08, and 09 speak to the requirements and responsibilities of guardians. Additionally, Superintendent's Rule 73 has been amended to provide a new provision concerning guardians' compensation. I'm going to now talk about the applicability of the rules. Superintendent's Rule 66.01 provides definitions for new Rule 66, giving all parts of the rule a common language. 66.01a defines best interest, direct services, guardian, ward, and guardianship services. The rules only apply to adult wards and not to minor guardianships. And the rules apply to all guardians for adult wards, including guardians who are related to the ward and guardians who are unrelated. Under Superintendent's Rule 66.02, however, probate courts may, for good cause, exempt a guardian who is related to the ward by consanguinity or affinity. The rules also apply to employees of corporations who provide guardianship services. Looking at the requirements and responsibilities of the courts, Superintendent's Rules 66.03 provides that probate courts adopt local rules regarding the establishment of guardianships. The new rules are not intended to impose undue burdens or limit the probate court's authority, but rather they support best practices to address situations that courts often experience. Specifically, under Superintendent's Rule 66.03a, the court is required to adopt local rules governing the establishment of emergency guardianships. The purpose of this superintendent's rule is not to authorize emergency guardianships, which are already authorized by Revised Code 2111.02b3, but rather for the probate court to articulate the process for establishing emergency guardianships. A local rule can provide clarity regarding the scope and breadth of an emergency guardianship. Rule 66.03 also requires that probate courts include a process for submitting comments and complaints regarding the performance of guardians appointed by the court, and a process whereby the court can consider such comments and complaints. The rules acknowledge the enormous powers that probate courts put in the hands of guardians, and as such, the rules recognize the need for a local rule to establish a complaint and comment process to ensure the protection of the ward's best interest. The Ohio Probate Judges Association is working on a model local rule that will be available to all of Ohio's probate judges. Superintendent's Rule 66.04. The rules recognize the dignity and autonomy of a ward must always be observed, and as a result, the powers granted to a guardian should be carefully drawn to make sure that the least restrictive alternative is imposed upon a ward. 2111.02c6. Under 66.04a, a limited guardianship must first be considered prior to giving the guardian plenary power. Further, the rules resolve a critical conflict of interest question by prohibiting agencies or programs that provide direct services to a ward from also serving as a guardian to that ward. This is pursuant to Rule 66.04d. Residential facilities, waiver programs, or their employees are not permitted to serve as guardians for a ward for whom they are providing direct services. Superintendent's Rule 66.05 is entitled Responsibilities of Court Establishing Guardianships. Generally, the rule gives courts only two new responsibilities when an individual files an application to be appointed guardian. First, the court is required to conduct or cause to be conducted a criminal background check on the applicant. Attorneys may submit a certificate of good standing with disciplinary information issued by the Supreme Court in lieu of the criminal background check. Second, the court must require each guardian appointed by the court to submit documentation showing compliance with the educational requirements of Superintendent's Rules 66.06 and .07. This is under 66.05a. 66.05b does impose on the courts additional responsibilities for close oversight of guardianship cases when a guardian has 10 or more guardianship cases. The rules are intended to assist the court in ensuring that the safety and welfare of wards is not compromised by the guardian's larger caseload. The court's responsibilities include maintain a current roster of all cases being handled by that guardian. Courts must also require those guardians with 10 or more cases to certify to the court that the guardian is unaware of any circumstances that may disqualify him or her from serving as guardian. In other words, that the guardian remains eligible to serve. Courts must also require those guardians with 10 or more cases to file fee schedules that differentiate direct services, such as legal services, from guardianship services. And last, the court must annually review the roster of those guardians in their court who have 10 or more cases in order, again, to ensure that those guardians remain eligible. The Ohio Association of Probate Judges is working on a model local rule to comply with these requirements, which will be available to our probate courts in each county. Requirements and responsibilities of guardians is the next topic. Superintendent's Rules 66.06 to 66.09 provide the requirements and responsibilities of guardians. Qualified, educated, and skilled guardians are the cornerstone of the new adult guardianship rules, and therefore guardianship training has been included as a requirement in the rules. Under Rule 66.06, guardians must have successfully completed the 6-hour Guardians Fundamentals Education course at the time of appointment or within 6 months thereafter. Any guardian serving on June 1st of this year, that's the effective date of the rule, or who has served as a guardian during the 5 years immediately prior to the effective date, shall have 1 year, that is until May 31st, 2016, to complete the 6-hour fundamentals course. The courses will be provided by the Ohio Supreme Court or another provider approved by the probate court of each county. A court may excuse experienced guardians from completing the fundamentals course under Rule 66.06b. An advanced education course under 66.07, which will be a 3-hour course, is required each year thereafter. A guardian who fails to comply with the educational requirements is not eligible to be appointed for other guardianships until the educational requirements are completed. The guardian may continue to serve as guardian in that particular case, but he or she would not be eligible to be appointed for other guardianships until the educational requirements are completed. Superintendent's Rule 66.08 speaks to the general responsibilities of guardians. The rule stresses the importance of keeping the court informed about the well-being of the adult ward. For example, guardians must notify the court if there is a change in the ward's residence, particularly to a more restrictive setting. This is under Superintendent's Rule 66.08e. If the ward's ability to make decisions and function independently has improved, the guardian is required to contact the court and, if appropriate, seek to modify the guardianship to a limited guardianship, or, if appropriate, even terminate the guardianship. This is under Superintendent's Rule 66.08d. If the ward's income changes so the ward's principal income is from a government entity such as Social Security, then a guardianship of the estate may no longer be needed, and that need needs to be reported to the court under Superintendent's Rule 66.08i. Guardians should report any actual or apparent conflict of interest for review and determination of whether a waiver of the conflict of interest is in the ward's best interest under Superintendent's Rule 66.08k. The rules underscore the importance of guardians knowing their ward. For example, under Superintendent's Rule 66.08b, the guardian must attempt to meet with his or her ward prior to receiving the appointment. Under Superintendent's Rule 66.08g, the guardian is required to prepare an annual plan indicating goals for the ward's personal and financial needs. This could be filed as an addendum to the guardian's report. A guardian is required to advocate for services that are in the best interest of the ward and help the ward reach his or her full potential under Superintendent's Rule 66.09d. Superintendent's Rule 66.09F2A requires a guardian to meet with his or her ward at least quarterly. Under 66.09H, a guardian must monitor and coordinate the services and benefits that his or her ward receives so that they continue to be in and for the best interests of the ward. And pursuant to Rule 66.09J, a guardian must make every effort to be informed about the ward's belief system and preferences, to make decisions consistent with said beliefs and preferences. This is especially true for end-of-life decisions. Now, looking at amended Superintendent's Rule 73, it requires, newly, this is the new part, requires guardians to itemize all expenses. And as you may recall, this fits under the Rule 66 change as well. This rule supports other rules that direct guardians to disclose to the court fees received other than through guardianship of the estate. This is under Superintendent's Rule 66.08J. A guardianship appointment confers on guardians enormous power over their wards. These new rules have been adopted to assist the courts and guardians in ensuring that the best interests of wards are protected. Information on education providers can be obtained through the Judicial College, and course information will be posted on the Judicial College website and in eAcademy. The Judicial College course offerings that will meet the requirements for both the Fundamentals course required by Superintendent's Rule 66.06 and the Advanced course required by Superintendent's Rule 66.07 will be held regionally throughout the state and will be free of cost. Additionally, local probate courts may, at their discretion, provide education that meets the rules requirements, or approve other providers, whether local, state, or national. This has been a very quick overview of the new rules. If you have further questions, the Supreme Court of Ohio Children and Families section is connected to other statewide groups and initiatives working on adult guardianship matters, and you can check with the Supreme Court to find out further information. Thank you for your attention. These new rules are intended to assist courts in maintaining good oversight over their guardians. We hope that they work well for you, and we look forward to any questions that you may have. Thank you.